Modern Real Estate Practice, page 180. To make it as attractive as possible, that could be used to help market the property effectively. At the end of this discussion, the seller should have an idea of what is involved in the sale process and should feel comfortable with the decision to list with the broker. The sale associate will also have questions for the property owner. Before the listing agreement is signed, the seller should provide comprehensive information about the property and indicate any personal concerns about the sale process. Based on this information, the broker can accept the listing with confidence that the seller's goals can be met in a profitable manner for both parties. Information needed for a listing agreement. Obtaining as many facts as possible about the property ensures that most contingencies can be anticipated. This is particularly important when the listing will be shared with other brokers through the MLS, and those real estate professionals must rely on the information taken by the sales associate acting for the listing broker. The information needed for a listing agreement generally includes the names and relationship, if any, of the owners, street address and legal description of the property, size, type, age, and construction of improvements, number of rooms and their sizes, dimensions of the lot, existing loans, including the name and address of each lender, the type of loan, the loan number, the loan balance, the interest rate, the monthly payment of principal, interest, taxes, and insurance, PITI, whether the loan may be assumed by the buyer and under what circumstances, whether the loan can be prepaid without penalty, and whether or not the lender has approved a short sale, one in which the sales price may be less than the amount of the outstanding loan balance, and if so, whether the seller will incur a personal debt for the difference. Possibility of seller financing, amount of any outstanding special assessments and whether they will be paid by the seller or assumed by the buyer. Zoning classification of the property, current or most recent years' property taxes, neighborhood amenities, for instance, schools, parks and recreation areas, places of worship, and public transportation. Real property, if any, to be removed from the premises by the seller, and any personal property to be included in the sale for the buyer. Both the listing contract and the subsequent purchase contract should be explicit on these points. Any additional information that would make the property more appealing and marketable, and require disclosures regarding property condition. Page 181, disclosures. Most states have enacted laws requiring that real estate professionals disclose whose interests they legally represent. It is important that the seller be informed of the company's policies regarding single agency, sub-agency, buyer agency, dual agency, and any other forms of representation allowed by state law. The residential property owner must also discuss the property's condition as required by law in most states. Property condition disclosures cover a wide range of structural, mechanical, and other conditions that a prospective purchaser should know about in order to make an informed decision. Frequently, state law requires that the property owner complete a standardized form that may require the owner to indicate the condition of specific property features, such as heating and plumbing systems. A real estate professional should always caution a property owner to make truthful disclosures to avoid litigation arising from fraudulent or careless misrepresentations. The listing contract. Real estate firms, local and state trade associations, and other groups have worked with their attorneys to draft standardized listing contracts that meet the needs of real estate brokers and their clients, and also comply with the laws and regulations that define acceptable business practices. In some states, independent publishers sell a variety of contract forms that are drafted to meet legal requirements. Even if all the contract wording is not mandated by law, many parts of the agreement may have to use specific wording and appear in a mandated type, font, and size so that they are clear and conspicuous. Because contract terms often appear mysterious to the untrained consumer, most states specifically allow a real estate professional to go over the terms of a pre-printed contract with a client without risking any accusation of the unlawful practice of law. Figure 11, period 2 is a sample exclusive right to sell listing agreement. It is provided as an example only. Many state-specific or regional forms are available online. In addition, many states make available handbooks and other reference materials for real estate professionals, as well as consumers that explain real estate transaction contracts and obligations. Each state real estate agency's website is listed in the appendix.